Hello everyone, this is Anupriyo Debnath, a trainee under LEXIS and Company for the month of June. So as you have already watched the title below, that this video is gonna be about equality before law. Now, what is the most important and the major aspect of it is people generally tend to get confused between equal protection of law and equality before law. So the basic answer is the functions make it very much different. Although they both conclude with equality among people, but the functions of them is very much different. So according to A.V. Dicey, the founder of Equality Before Law, he said that law is supreme. Now what does it mean by law is supreme? Law gives commands to all. No matter it's the government or the governor, it makes the treatment of equality equivalent among people or the citizens, no matter which category, caste, creed, sex or any such discriminations is provided. So we can get the glimpse of equality before law in the preamble, which talks about the opportunity and the statistics. So the location where the equality before law is found is in the preamble and the Indian Constitution. The preamble says that equality before law is basically the opportunity and the distinctions for people, whereas Article 14 under Indian Constitution talks about the equality before law and the equal protection of law as well. So this video is going to be about three different topics under equality of law, that is the rule of law and the equality before law, and number 3, the case laws. Let's start with a basic illustration. Suppose you have a sibling at your home. Now you guys are treated equally, but he or she is younger than you. Now if the book materials and the food materials or the quantity and the sufficiency of food and the livelihood or the clothes is same being provided, is it equal? No, na? Then the equality before law takes action. It says equality before law means people are all general and all specifically common and equal in front of the law. Whereas equal protection of law defines when few people with common actions or common interests being make a group will make a equal protection of law. Means all people in general are equal in the eyes of law. Whereas equal protection of law is all the individuals in the group have equal protection towards the law. Basic difference between equality before law and equal protection of law. Number 1, equality before law comes under Article 14, subsection 1. Whereas equal protection of law defines when few people with common actions or common interests being make a group will make a equal protection of law. Means all people in general are equal in the eyes of law, whereas equal protection of law is all the individuals in the group have equal protection towards the law. Basic difference between equality before law and equal protection of law. Number 1, equality before law comes under Article 14, subsection 1, whereas equal protection of law comes under Article 14, subsection 2. Equality before law is the English law, means we have got the concept from the English law, whereas equal protection of law is the American law, which we got from the Americans. Number 3, equality before law is basically a negative approach, whereas equal protection of law is a positive approach. Equality before law in a general sense is very generic, whereas equal protection of law is very much specific because equal protection of laws, it's a plural. Therefore, Lady Justice has a blindfold on her eyes. That means that every person or every people who comes to court is all equal in the eyes of law. So, the public welfare decided to classify their distinctions or differences among such clot or groups to make such different laws or to protect the laws. So now comes to case laws. In the case of State of Bombay versus FN Balsara, it was stated that there should be a test conducted which very much provides the classifications of equal protection of law. The test included two different categories or divisions. Number one is the intelligent differentia and number two is the rational nexus. Intelligent differentia means the test should conduct a very much intelligent process or very much intelligent questions which will better or which will make better conclusions on differentiation of people. And rational nexus means the test which is confirmed or which is conducted should make a rational nexus or link with the conclusion or the group which is being made. Under E.P. Rayappa versus State of Tamil Nadu, it was saying that the old doctrine which was invented in 1970 got lapsed because the new doctrine resolved that rule of law plus natural justice altogether makes it a new doctrine. Number 3, Maneka Gandhi versus Union of India stated that the test or the new doctrine should exclude the arbitrariness because the fairness and equality should be very much promoted. This will further make the 3 golden articles including Article 14, Article 19 and Article 21. Now we will talk about the common questions under equality before law. Number 1 is, what does equality before the law guarantee? Equality before the law guarantees that people all in general are equal in front of the eyes of law. Number 2, how many articles are there in the right to equality? From Article 14 to Article 18 altogether concludes the equality for the people or the citizens. Number 3, does Article 14 apply for foreigners? Yes, Article 14 applies to all the people because it's about the equality no matter where you are or who you are. Equality means no discrimination. Number 4, what are the exceptions of it? The exceptions of it are, under Article 105 and 194, the members of the Parliament and the state legislatures respectively are not held liable for anything which they say within the House. Number 5, does NRC violate Article 14? Exercise. The answer is yes. The recent article says exercise of the manifest arbitrariness will hamper Article 14.